I'm going to check to see if we have questions. This is a really good question. It goes back to the discussion we had about the 401k and the ex-spouse being the beneficiary. And the question is, can that ex-spouse sign a waiver on receiving the asset? And the answer is maybe. It really depends on whether or not the entity that holds the 401k, whether they can and are willing, and whether the laws allow that ex-spouse to receive it, to waive that receipt. I honestly cannot answer that question, but it's definitely a great question looking, and you can look into it. I can say that under just probate law, there is an ability to disclaim an inheritance. And if you disclaim whatever you're receiving, then it should go to whomever is next. If there's an alternate on it, if there's not an alternate, then it would pay to the estate, and then through the estate would pay probably where that person who died would want it to go. So yes, there are solutions more likely to occur if the spouse and the ex share children, less likely to occur if that ex-spouse has no family ties to whomever would be receiving under the will. Excellent question, though. All right, so a couple of other, we do have a few more minutes, so I wanted to give you a few bonuses here. And I had mentioned earlier that probate can be a good thing. You probably have heard the word probate, and it's not quite a 4-letter word, but you might say avoid probate at all costs. And that's really not an uncommon thing that you hear, is probate is bad. I'd like to show you an example of how probate actually can be a good thing. So let me set it up a little bit. Let's say that we have a married couple and they are concerned about long-term care costs. Let's say they're retired and maybe they have a diagnosis, one of them, maybe they don't. Statistically, probability-wise, people who are of a certain age will require long-term care. How long? How intensive? That all depends. But I do understand that people who are seniors, people who are retired, often they don't have long-term care insurance. One of their main concerns is that they're going to run out of money in the event of a long-term care situation. So what can they do to make sure that they've provided for their spouse? So with that scenario, in the state of Washington, the only way that you can protect and make sure that your surviving spouse has money when you're gone is to do so through a will. And a will means that there has to be a probate. And I'm hoping that you can see my screen here that talks about a will with an asset protection supplemental needs trust. So what this is the couple creates an estate plan. And what we do is we put a trust into the will. Takes effect on death. Let's say we have a married couple, they have $1 million. We don't know who's going to die first, and it's Washington's community property. The first spouse to die, in my example, and I'm not quite sure if you can read it well, but we'll take Fred and Betty. They have a $1 million estate. Betty has Alzheimer's, so they know Betty's going to need care, but Fred's been taking care of her. Fred dies first, though. So what's going to happen is his share of the assets are going to go through his will, through probate, into an asset protection trust for the surviving spouse, Betty. We've protected $500,000. It will never interfere with her eligibility for Medicaid should that later be sought. And this 500,000 will go exactly where Fred said it should go, for example, to the couple's 2 children, whatever the case may be. If we have advanced knowledge and warning that Fred's going to die, we can, through a strategy of transferring separate property agreement, transfer all assets, we can put it all into the name of the spouse who's going to be dying. In this case, that is Fred. He dies first. The $1 million is all his. It all goes to the Asset Protection Supplemental Needs Trust through the probate process. So why that's so important is that through having the right estate plan, a will with a special kind of trust in it, for this client, we can protect half up to 100% of their estate. And if Betty needs care, which she will, facility-based memory care, she will be able to get that care and have money to pay for it. And at the 50% scenario, perhaps she has to spend $500,000. Perhaps not if she sees an elder law attorney. We have other strategies. If we have the $1 million asset protection, she qualifies for Medicaid right away. Single person can only have $2,000. She has none. Everything's in the trust, and the trust doesn't count because it was done correctly. So correctly meaning through a will. You cannot accomplish this result through a revocable living trust. So yeah, maybe the revocable living trust costs less to set up, maybe not. Maybe the revocable living trust saved $10,000 in estate planning, in probate expenses at the end of a life, and then you lost the ability to protect $1 million. Bad result. Having the right will, having probate, all of those things cost money. All of those things are legal fees. The result is $1 million in asset protection. Now, Betty doesn't need to go on Medicaid. Maybe she's in a memory care for a year or 2 or 3 of private pay, but she's eligible for Medicaid. Let's say that she needs to go immediately into skilled nursing care where there's no private pay requirement. Medicaid is accepted. We've got $1 million in trust to perhaps pay for a private room. There's so many things that you can do with money. Money makes it so much better for her care. But that is one of the reasons that probate might be a really good thing. So, all right, a couple more questions. So this questioner here knows a lot. So the question is, in a will, can you add a clause that says something that if somebody is a joint signer or they're a beneficiary, that they're really not supposed to get all of that? Yes, you can. There is, in Washington at least, there's something called a super will provision. That's what we lawyers call it. Because it says, if I designated somebody on this bank account and I did so before the signing of my will, even though they're a joint owner or if they're the beneficiary or pay on death, I don't really want them to get it. I want it to all go under my will, which is a possible solution. But keep in mind that that super will provision has no effect on what happens after the signing of the will. So if after the will was signed, then there's a beneficiary designation or a joint owner or something like that happens, the will and the super will provision didn't fix it. So